Welcome to another TDW Tech Bite. In this recording, I'm going to focus primarily on issues that arise where a Hong Kong business is receiving personal data transfers from a data controller or data user that is located outside Hong Kong. In other words, where the Hong Kong business is the data importer. I want to introduce and speak to you about transfer impact assessments. I'm going to speak about what is a transfer impact assessment, when is it commonly used or required, what is the focus of a transfer impact assessment, what are the typical questions that are asked, and is this something that will be increasingly used by virtue of trends in international data privacy regulation. Firstly, what is a transfer impact assessment? Many of you will already be familiar with privacy impact assessments. Well, a transfer impact assessment is a similar but perhaps narrower tool. It's a tool that is used in order to inquire into and effectively due diligence the concerns that may arise in the context of the transfer of personal data from one jurisdiction to another different jurisdiction. The framework for a transfer impact assessment will require an assessment of the data itself, an inquiry into the means by which that data is going to be transferred, an assessment of the laws in the receiving jurisdiction or importing jurisdiction, and also an assessment of the protections that will be accorded either by virtue of the arrangement or by the security of the personal data where it is held, and an assessment of the review and enforcement measures that will be applied. So there's quite a few elements to it. Transfer impact assessments really came to the fore following the Schrems II judgment by the Court of Justice of the European Union under GDPR principles. There was now a requirement where an EEA data exporter is transferring personal information of persons who are in the European Economic Area to locations that are outside of the European Economic Area. One of the core assessments that must be made is to see whether the laws of the importing jurisdiction meet four key privacy safeguards and guarantees that have been recognized almost to the level of human rights within the European Economic Area. The kinds of questions that a Hong Kong data importer may be asked will be questions like a description of the general framework of data privacy and protection within Hong Kong, a description of the rights of access by enforcement authorities and public bodies to personal data that is kept within Hong Kong, the availability of notices to data subjects, and rights and remedies of data subjects in respect of enforcement actions accessing personal data within Hong Kong. Now, a transfer impact assessment may be triggered in the GDPR context in respect of a Hong Kong data importer to the extent that the Hong Kong data importer is receiving personal information and personal data from an data exporter that is based in the European Economic Area. That's basically the EU plus 3 other countries. There's also a second, less well-publicized situation in which a transfer impact assessment may be required, and that is where there is a Hong Kong data exporter, but the data exporter is subject to GDPR. Please remember that GDPR has extraterritorial effect. And if you are a business in Hong Kong that actively monitors persons who are in the European Economic Area or actively sells and markets goods, products, and services to persons in the EEA, then you may be subject to GDPR. And if so, then you'll also be required to conduct transfer impact assessments, but as a data exporter. We are frequently requested to advise in respect of transfer impact assessments. It's usually in the context of providing guidance on the system of law that applies in Hong Kong and its adequacy in respect of the protections afforded to data subjects compared to the protections in the European Union. With a particular focus on those 4 privacy safeguards and principles that have been guaranteed in EU laws as human rights. This is a rather detailed analysis and overview of rights of access to personal data in Hong Kong by enforcement authorities. In general, Hong Kong stands up to and meets international standards, but of course there are always issues that might arise because of the specific context or the kind of personal data that is in question. One of the things that's important to keep in mind is that this is a trend. It may have started with GDPR as reflected in the Schrems II judgment, but it is a trend that is broader than that. If you look in the context of the security assessment measures that have been recently promulgated in the rest of China in the PRC, you will see that a data impact assessment is part of the processes that must be followed where personal information is being transferred from mainland China to locations outside of mainland China, and that would include Hong Kong. One can imagine that in the context of that data impact assessment, there will also be elements of a transfer impact assessment, because the underlying principle is that the personal information that is held within Hong Kong should be protected to the same level and to the same standard as applies under the Personal Information Protection Law, Data Protection Law, and Cybersecurity Law of mainland China. So transfer impact assessments are here to stay and will become more common and increasingly a standard in respect of international data transfers.